Hello everyone, welcome to Law Stories. In this video we will see nullity of marriage, when a marriage will considered invalid. We learn this under section 11 and 12 as void and voidable marriage respectively. First, we will learn about void marriages. Section 11 of the Hindu Marriage Act, 1955 deals with void marriages. And, a void marriage is invalid from the beginning, that is, void ab initio. It has no legal effect. When is a marriage void? A Hindu marriage will be void if it violates any of the three conditions under Section 5 of the Hindu Marriage Act. First, bigamy, under Section 5 Clause 1. If either party already has a living spouse at the time of the marriage, the subsequent marriage is void. For example, if a man marries again without divorcing his first wife, the second marriage is invalid. Second, prohibited relationship, under Section 5 Clause 4. If the couple is related within the prohibited degrees, such as brother and sister, or uncle and niece, the marriage is void. However, if there is a valid custom or usage among them that permits such a marriage, then it is not void. Third, sapinda relationship, under Section 5 Clause 5. If the couple are sapindas of each other, meaning they are close blood relatives within certain generations on both sides, the marriage is void. But again, if there is a valid custom or usage that permits such a marriage, then it is allowed. When is a marriage void? A Hindu marriage will be void if it violates any of the three conditions under Section 5 of the Hindu Marriage Act. First, bigamy, under Section 5 Clause 1. If either party already has a living spouse at the time of the marriage, the subsequent marriage is void. For example, if a man marries again without divorcing his first wife, the second marriage is invalid. Second, prohibited relationship, under Section 5 Clause 4. If the couple is related within the prohibited degrees, such as brother and sister, or uncle and niece, the marriage is void. However, if there is a valid custom or usage among them that permits such a marriage, then it is not void. Third, sapinda relationship, under Section 5 Clause 5. If the couple are sapindas of each other, meaning they are close blood relatives within certain generations on both sides, the marriage is void. But again, if there is a valid custom or usage that permits such a marriage, then it is allowed. Now, let us see the effect of a void marriage. A void marriage creates no legal status between husband and wife. It gives rise to no rights and no obligations between them. For example, the parties cannot claim rights such as inheritance or maintenance. However, children born out of such a union may still have certain legal rights. The parties are free to treat the marriage as null, even without going to court. But for clarity, they may still approach the court and obtain a formal decree of nullity. Who can file a petition for nullity of marriage? Only the parties to that marriage, that is, the husband or the wife, can file a petition for nullity. The first wife cannot file for nullity of her husband's second marriage. However, under the Specific Relief Act, the first wife can move the court for a declaration that her husband's second marriage is illegal and void. Now, let us see the difference between a void marriage and a voidable marriage. A void marriage is invalid from the very beginning. It has no legal existence in the eyes of law. It creates no status of husband and wife between the parties. No legal rights and obligations arise from it, such as inheritance or maintenance. For example, if a person marries during the lifetime of their spouse, the second marriage is void. It is as if no marriage ever took place. On the other hand, a voidable marriage is different. It is considered valid and continues to exist until a competent court passes a decree annulling it. This means, unless and until the marriage is annulled, the parties are treated as legally married. Rights and obligations like consortium, inheritance, and maintenance do arise. Once a decree of annulment is passed, the marriage becomes void from that point onward. Thus, the key distinction is this: a void marriage is automatically null and has no legal effect at all. A voidable marriage is legally valid until challenged and annulled by a court of law. Now let's understand voidable marriages under Section 12 of the Hindu Marriage Act, 1955. Unlike a void marriage, a voidable marriage is considered valid in the eyes of law, unless it is annulled by the court. This means, the marriage continues to exist and creates all rights and obligations between husband and wife, until a decree of nullity is passed by the court. So, in simple words, a voidable marriage looks valid, works like a valid marriage, but can later be cancelled if one of the parties approaches the court. Let's look at the first ground of annulment under Section 12, subsection 1, clause, impotency. A marriage can be annulled if it has not been consummated because the husband or the wife is impotent. In the case of G. Venkat Narayan vs. Kurupati Lakshmi Devi, A. 1985 Andhra Pradesh 11, the court explained this clearly. It said, only incapacity to consummate is a valid ground for annulment. If by the time of the petition, the person has become capable of consummation, then the court will not grant a decree of nullity. The court also held that medical tests for potency are valid, and they do not amount to violation of privacy. Next ground is under Section 12, subsection 1, clause B, unsoundness of mind. A marriage is voidable if, at the time of marriage, either party is incapable of giving valid consent because of unsoundness of mind, or suffers from a mental disorder that makes them unfit for marriage or for having children, or has recurrent attacks of insanity. In such cases, the marriage is treated as valid until challenged, but it can be annulled by the court on these grounds. Now let's move to Section 12, subsection 1, clause C, consent obtained by force or fraud. A marriage is voidable if the consent of the petitioner was not free, but obtained by force, meaning actual violence, or even a threat of violence. Fraud, meaning concealment or misrepresentation of a material fact about the other party. If the court is satisfied that the consent was not genuine, the marriage can be annulled. Let's look at some examples of fraud under Section 12, clause C. Fraud includes concealment of a serious disease, such as leprosy or a venereal disease, hiding true age, concealing previous marriages, not disclosing the existence of an illegitimate child, or even pretending to be divorced when in fact the divorce has not taken place. On the other hand, certain things are not considered fraud. Earlier, before the 1976 amendment, hiding past unchastity or a venereal disease was not treated as fraud. But after the amendment, concealment of any material fact can amount to fraud and make the marriage voidable. Let's see an important case law. In Ramakanta vs. Mahinder Lakshmidas, A. 1996 Punjab and Haryana High Court, the wife had already been married twice before the present marriage, and she also had a son from her first wedlock. These facts were not disclosed to the husband. The court held that this was fraud, and the marriage was annulled on this ground. Now, about the limitation period. A petition for annulment must be filed within 1 year of discovering the fraud or when the force has stopped. Also, if the petitioner, after knowing the truth, still cohabits willingly with the other party, then they lose the right to annul the marriage. Now let's move to Section 12, subsection 1, clause D, pregnancy of wife by another person. A marriage is voidable if, at the time of marriage, the wife was already pregnant by someone other than the husband. Let's see a case. In Mahendra vs. Sushila Bai, A. 1965 Supreme Court, the wife gave birth to a child within just 171 days of marriage. This clearly proved that she was pregnant by another man at the time of the marriage. The Supreme Court therefore annulled the marriage. Now, let's see the limitations for annulment under this ground. First, the husband must prove that he was completely unaware of the wife's pregnancy at the time of marriage. Second, the petition must be filed within 1 year of the marriage. And third, if the husband, after discovering the pregnancy, has marital intercourse with the wife by his own consent, then he loses the right to annul the marriage. Now, let's understand the limitations under Section 12, subsection 2 of the Hindu Marriage Act. For cases of force or fraud, the petition must be filed within 1 year from the date the fraud was discovered or from the time the force has ceased. Also, if after knowing the truth, the petitioner willingly lives with the other spouse as husband or wife, then annulment cannot be claimed. For cases of pregnancy by another person, the petitioner must prove that he was ignorant of the fact at the time of marriage. The petition must also be filed within 1 year of the marriage. And finally, if there has been sexual intercourse with free consent after discovering the pregnancy, then the right to annulment is lost. Now, let's see the distinction between a void marriage and a voidable marriage. A void marriage is invalid right from the beginning. It is considered no marriage at all, and strictly speaking, no decree is needed to declare it void. On the other hand, a voidable marriage is legally valid and continues to create rights and duties between the parties. But, it can be annulled by the court. It remains valid until a decree of nullity is passed. Now let's discuss the legitimacy of children under Section 16 of the Hindu Marriage Act. The law says that children born from both void marriages and voidable marriages are treated as legitimate. This means, even if the marriage itself is not valid, the child's status is protected. But there is an important limitation: such children can inherit property only from their parents, that is, the mother or father. They do not get inheritance rights in ancestral or coparcenary property of the Hindu joint family. Thank you.